as well, because of the self-criticism that one has heard from the judiciary, as Mr. Divan just read out, the 7 sins. There have been repeated demands also from some outstanding judges that we've known over the years. Justice Krishna Iyer, for instance, has written repeatedly about how accountability has to be raised, levels of accountability have to be raised in the judiciary. Also changes that need to be made in the manner in which judges are appointed, judges are made accountable, how to make that procedure more transparent. And what I believe we were doing is responding to this demand and ensuring within this demand to retain an acceptable balance and obviously keeping our eyes riveted to the most important principle involved, and that is the independence of judiciary. And accountability as part of that independence is what we thought needed to be done. Several models have surfaced over the years, and now finally the Lok Sabha, after a debate of 4.5 hours, in which several very, very successful lawyers participated as well, passed the bill, which is now to go to the Rajya Sabha. But if there are any doubts about the consequences or implications of that bill, we would certainly respond at this very stage to ensure that those doubts are removed, and if there needs to be any further amplification or modification or improvement to be made, we will certainly do so, although it's property of the House. But I share this with you in all modesty. What we want is something that is an enlightened piece of legislation acceptable to all stakeholders, the most important of all, the judges themselves. It's broadly, the legislation is based on the Judges Inquiry Act, and obviously on the premise that the decision finally has to be taken by Parliament, but the experience of what we have to go through till we actually get to Parliament, and the frustrated investigations or inquiries in the past that haven't allowed Parliament to take a final view, or for that matter, even when it's got to Parliament and the divide within Parliament has not permitted an impeachment to go through, is something we kept in mind. But I'm only mentioning this because I saw this very important, significant intervention reported in newspapers from a person that I cannot, even for a moment, overlook in terms of responding to his views and taking his views on board, as indeed I'm sure other judges or retired judges have also felt that way. Now coming to the topic itself, the topic of the rule of law. I think there is a major issue here in rule of law that we need to reflect upon, and that is not simply the conceptual properties and the conceptual dimensions involved in understanding what we mean by rule of law, but also to look at the mechanics of ensuring that rule of law prevails in the country. And broadly speaking, rule of law is like democracy. We understand democracy broadly speaking. We understand rule of law broadly speaking as opposed to the rule of men. But the rule of law can, of course, include the misrule of law. And that's something that leads us back to the conceptual propositions. But just as democracy, fairness, justice are broadly understood, and sometimes truth broadly understood, we have to specifically examine the concepts involved and the larger conceptual framework to understand the rule of law. Particularly in our times in this country, where many propositions, beliefs, and articles of faith, if I might call them, are actually very, very, very aggressively contested by different groups and constituencies. If we didn't have that, we wouldn't have the huge number of very, very trying situations that we are faced with today. Look at what is happening in Odisha, for instance, and the entire belt of the Naxalite influence. Look at what's happening with minority groups that are complaining about insensitivity towards their concerns. Look at what is happening with social relations at the level, at the ground of Indian democracy. What is happening with honor killings, for instance. Look at what is happening with the treatment of women and children and the girl child. We've seen all this in the last 2 or 3 days on television. Look at also what is happening with contested impressions and perceptions about the media. The Supreme Court now taking on board all those concerns, aspirations and issues and trying to provide guidelines or some direction as to how media should play a role. You've had a very significant section on paid news because that distorts democracy, is our understanding. Look at how democratic institutions are being challenged by other, if I might call them, informal institutions outside the formal institutions of democracy. Outside the formal institutions of democracy also exist a lot of informal institutions of democracy, and civil society, I assume, can be described as one of them. They're not illegitimate, they're not to be ignored, they're not to be bypassed, they're not to be crushed, they're not to be ostracized. They're also a part of Indian democracy. The difference, of course, is that when you look at institutional forms of democratic institutions and look at their constraints, look at their work procedures, look at their accountability issues, they are vastly different from the informal institutions of democracy. So we need to find a conceptual framework in which both can be balanced and both can be taken on board so that the substance and quality of our democracy can be more wholesome and can continue to grow. Democracy is not and one-off thing. Democracy is an evolving thing, and we as a people have agreed that democracy is not only about elections, but democracy is about participating in decision making, but in the participation of decision making, the prioritizing of opinion is in a sense guided by election results. But we all know that election results have never in any good democracy been accepted as the last word. The most important word, the most significant word, but not an absolute final word, because it's the constitution that prevails over democratic choice of a majority. There are areas which some jurisprudence have called trump cards of democracy, where you can use a trump card even against a majority. But what is the majority's legitimate expectation and the right, and what is a minority's entitlement is again a contested view sometimes in our country, and it goes back fundamentally to conceptual frameworks. Now, conceptual frameworks emerge from universities, and I believe some of our universities are doing outstanding work, particularly now. Law universities have, I think, taken the level of legal education much higher than many of us had ever hoped to get when we were at law college. And they're hopefully producing not just commercial lawyers, not just boardroom lawyers, not just good advocates and future judges, but are also hopefully producing people who think about law, about philosophy of law, about political philosophy, and about the political economy, because ultimately law becomes an instrument of protecting, preserving, and evolving those institutions. But at the end of the day, whether it's Parliament, or it's the universities, or it's conclaves like this one, or informal exchanges that take place between professionals concerned with instruments of democracy and institutions of democracy, somebody must have the last word. And if I'm not wrong, and there is no ideological difference on this proposition, the last word in our democracy is left with the highest court of the land, and that's the Supreme Court of India. So no matter the Supreme Court of India gets the decision wrong, it will have to be a decision that we must subscribe to and must bow to till such time that we are able to persuade the court or another generation of judges of that court that that decision requires a fresh look. We know that. I don't need to tell you. ADM Jabalpur. The court itself thinks, both outside the courtroom and inside the courtroom, the court itself thinks that ADM Jabalpur was wrong, never being reversed. I assume that the court itself perhaps thinks that the Reddy Chatterjee's lover case is wrong. Judgment is wrong, but it's never been overruled. And presumably, like that, there may be many decisions of the court that have become outdated, that have become Jurassic, but there hasn't been an occasion to overrule them. But they remain in that sense law, just like many old legislation that become redundant and become rusty, but remain on the law books till such time as somebody scavenges for them, removes them, and then actually takes them to Parliament to delete them from the law books. So, be that as it may, the last word remains with the court. And of course, if the last word remains with the court, a rule of law is what is pronounced by the court to be the final point of view that must prevail in the system. The questions then arise, how does the court do it? If we look at the American court is stable for sometimes for decades together, because judges who come on the Supreme Court are there for a lifetime, and they don't retire sometimes till they see an option of their successors being chosen by a friendly president, and they carry on even late into their life in advanced years, because they're still waiting for a suitable president to come to pick their successors. And how the court transforms itself gradually from a radical court to a conservative court, to a court that changes its position on contested issues like healthcare, abortion, on death penalty, for instance, and a whole lot of other areas of desegregation, etc. All financing of elections takes place over a long period. The Indian Supreme Court can change over 6 months. The entire face of the court can change over 6 months with rapid retirement and changes of the profiles of judges in a matter of a few months. 6, 7 went last year, and a few more will go this year. And in a period of 12 months, the entire court will change. The Chief Justices will change. When the present American Chief Justice took over as Chief Justice, he was, I think, about 45 years old. He hadn't been on the Supreme Court even for a day, and he was taking over a Supreme Court in which there had been judges for 30 years. And he will continue to be, I assume, on the bench for another 25 to 30 years. At about the same time, our Chief Justice took over, who had been on the Supreme Court for 6 years, and would, after becoming Chief Justice, be Chief Justice for about a year and a half or 2 years and then retire. And during the tenure of the Chief Justice of the United States of America, we would probably get about 20 or 25 Chief Justices to steer the court in our country. Now, is that a satisfactory situation to find people who have the last word on the rule of law, on democracy, on our entitlements, on our relationships within the democratic framework, on things which vary, will go from one extreme of giving you freedom, emancipation, giving you dignity, to the extreme of actually ordering you to be hanged. This is the range of decisions the Supreme Court can take, and should that Supreme Court have the kind of stability that one would expect for the last word speaking authority in a particular system. Then again, our Supreme Court has some interesting propositions that we have inflicted upon the Supreme Court. If I may just broadly describe what is called a doctrine of necessity, Pakistan Supreme Court used it once upon a time, the doctrine of necessity to uphold the legitimacy of military rule. And this obviously had a limited gravitational pull because no other court in the common law world was going to subscribe to the doctrine of necessity. But curiously, there is our own Indian version of doctrine of necessity, for which I think the political institutions are responsible. Take the case of CNG in Delhi, the changeover from liquid fuel to CNG in Delhi. This was done because the court felt it was a necessity, that legislature and government were unable to take that very difficult decision. And there were a whole lot of reasons being given for why the legislature couldn't do it, but the court insisted. And despite protestations of all kinds and all sorts of reasons being given why it would not be possible, we do know that Delhi there is cleaner because the court insisted and took upon itself, while almost like under the principle of necessity, to intervene. And I think several times in public interest litigations the court has said this, that we cannot sit and twiddle our thumbs when someone comes and complains to us that there is something happening in this country and the elected government of the day, the administration, is not capable of doing anything about it. We will have to intervene. And that then begins, in a sense, our own version of doctrine of necessity. There is also a companion doctrine of the political question. Interestingly, the American Supreme Court refused to interfere in the Vietnam War issues by saying it's a political question which is outside the purview of judicial review of administrative action. Political questions must